Thank all of you for coming. It's very nice that the four of you woke up early, because no one else apparently did. So this is a really basic talk, so if everybody of all of the four of you already know, I know Jason knows a lot about free software licensing already, feel free, we'll just stop the talk and we can have a group discussion of something more advanced. I proposed this talk because I know there's a lot of people who come to this conference who are new to free software, and I think they're often very surprised to see the level to which people discuss licensing details and minutia. It's a common perennial topic that people get obsessed with in free software, and I've always known this quote about how many angels can dance on the head of a pin. This is actually the first time that in recorded knowledge that someone wrote down that point. This is where its original source of people debating these silly minutia of a topic to the point of absurdity. So I actually don't think that's the case about licensing, because I think licensing is very important and we interact with a lot. They didn't have this here at this conference, but often, particularly in hotels or airports, when you access a Wi-Fi network, it will ask you to agree to some license, some terms and conditions. You set your ESSID, and then there's this browser window that pops up before you can actually connect and get DNS responding properly, that you have to agree to these terms. And how many of you have read those terms before you've agreed?
Sometimes.
Oh yeah, so you see that you've self-selected for the licensing geeks that you do, right? I mean, most people don't read them. I always read them. I actually once saw one that said you can engage in no commercial activity whatsoever on the network. So this was at a conference, a business conference, right? So how many people were actually engaging in their work, i.e. commercial activity? Now the funny part was I agreed because I work for a charity. So I was like, well, I'm not engaging in commercial activity even if I'm doing work, but everybody else is because they work for companies. And of course they're violating them, and the point can be made that it's highly unlikely that it will be enforced. But it matters what permissions you have to do things. And this is kind of a toy example because it's unlikely that they're going to litigate against people who do commercial activity on these networks unless they're doing it. What they actually mean probably is they want people using the spam and those sorts of things, and they would prosecute somebody like that, but they actually said any commercial activity is prohibited. There are consequences to what you agree to in licenses, and it matters what they say. Here's an interesting example of what happened with the Google Maps API. So many people, when they design a website, the restaurant we bought the food from last night had a Google map on their website of how to get there. Well, whoever designed their website just hooked it up to the Google Maps API, and it's all probably working fine, except they probably didn't notice the terms that if that restaurant becomes very popular and gets over 25,000 hits against the Google Map API in a day, the Google Map API will stop answering requests from that website. So this is the thing that was apparently in Google's terms and conditions on the Google Maps API for years and years. Nobody read the licenses, and they started enforcing it because they realized too many people were using their maps and they wanted to get paid for their proprietary software, their Google Maps. And since it's not free software like OpenStreetMap and not free data like OpenStreetMap, they can do that, and people can be hit by a surprise that they shouldn't have been surprised about because it was in the license to begin with. So the interesting thing about free software is it all started because we all hated licenses. We wanted a world where software licenses didn't restrict us from doing the things we thought we should be allowed to do in freedom. However, the only solution we came up with was to use licenses to solve the problem. This is because by default, in basically every country in the world, software is governed by copyright. Now I'm going to get to it. Oh, that is a robot somebody's driving around out there. Rather noisy one. Anytime you put a expression of idea into a tangible medium, i.e. you type it into a text editor, it begins governed by copyright, yeah.
How is code tangible? Tangible means you can like reach out and like.
Yeah, so that's a good point. The question is well, why are things that are electronic tangible? The tangible medium in software is the hard disk, which is tangible. So it's put into it's affixed in a physical device, a medium. So that's generally what people believe. Certainly, there is the point that this copyright law was written before hard drives existed, but that's how the courts have generally interpreted electronic medium as meaning like a CD is a tangible medium, as another example. So the only way that you can get the rights to do anything with software is if you have a copyright license for that software. Otherwise, you're prohibited from doing everything that copyright law governs. So for free software, the rights that we wanted to make sure everyone had when the community invented free software licensing were these 4 freedoms. The most important thing is everybody should get the freedom to use the software for any possible purpose that you can think of. The second freedom that folks wanted to make sure that people would get with free software was the right to fix problems with it by making modifications to it and being able to read the source code and learn about how the software works. This was a fundamental freedom that the early folks in the free software community felt people should have. The third freedom was the idea of being able to help your neighbor, share copies of the software with other people, having the permission to give someone a copy of the software if you wanted to. And generally in the free software world, people believe that should not discriminate between commercial and non-commercial activity. You should be able to share it as an altruistic act, or you should be able to share it for a fee. You should be able to charge people for software, and that those two activities should be treated completely equally. The final freedom is the freedom to combine the previous two. The freedom to modify the software and then distribute those modifications, those improvements to other people. Again, free software licenses do not discriminate between commercial and non-commercial activity. You have the right to sell your expertise in modifying and improving the software, or sell copies of your improved versions, or you have the right to just do it because you want to help the community and share your changes freely on a mailing list with others. So what has to happen, because software is governed by copyright, if you want to give people those 4 freedoms, you have to have a license that does it, because you have to embody those rights into some document that will pass those freedoms along using the copyright system that already governs the software. Generally speaking, it differs around the world, but usually copyright statutes around the world govern 3 specific activities: copying, modifying, and distributing the work, the copyrighted work. So any license, a copyright license, that's going to give you those freedoms is going to have to govern the rules for what you can do when you copy, modify, or distribute the software. Now, if you don't give someone a license, if you just hand them software and don't say what their license is, the software is by default copyrighted. Any country that has signed the Berne Convention on Copyright, this is true, and they can't do any of these things. They're prohibited legally from doing any of those activities, copying, modifying, or distributing the software. So the license is the document that gives you back those permissions, which you otherwise would not have if you didn't have the license. So every free software license that you encounter is going to first do this. It's going to assert your right to copy, modify, and distribute the software, that you have an affirmative right to do all those things, granted to you by the person who holds the copyright on the software. So there are a lot of licenses. There was a period of time, I'm credited on Wikipedia as being one of the first to argue against license proliferation. I think that's probably true. But there was a time when people were writing lots of new open source and free software licenses. It was kind of a fad in the late 1990s for a company to get involved with open source by writing their own license. So there are a lot of these out there. There are basically 2 authorities that maintain license lists. They both have booths downstairs in this conference. The first one is the Free Software Foundation, and I actually am credited with inventing this list, mainly because I was the volunteer webmaster for the FSF and volunteered answering the general contact address in the late 90s. and most of the questions were what licenses are free software licenses. So I suggested that we make a page that has a list of them. And so I founded this list, as it turns out, because I got sick of answering FAQs, basically. And so that list has a list of all the licenses that the FSF considers free software, and some of the ones that are very popular but are not free software. And it also has a subset of the list, a proper subset, which is the GPL compatible free software licenses. I'm going to talk a little bit later about what GPL compatibility is. So if you see a license and it's on that list, and it's also on the Open Source Initiative's list of open source licenses, if you find it on both those lists, you can generally assume that it's a reasonably good license if it's on both the GPL compatible list by the FSF and the OSI's list. So you can just, if you want to pick a license for your new project, or you download something and you're wondering what license is it, look for one of those two lists, and if it's on both those lists, if you want to walk out now and say, okay, now I know what to do, I just check those lists. You could just remember that part, and you'd be just fine. The reason the talk doesn't end here is because what's actually happening, the reason many licenses exist, is they embody different policies for how free software communities are governed. Free software licenses are basically the constitution of that particular community, of how they're going to govern themselves and what their rules. Now, there's often other rules and other community norms that exist in free software projects. Just like in a society, there's not just a constitution, there's also laws. But the license is the first document, the founding document that decides how a free software community operates, and that's a question of policy. So a lot of people, not the people who got up this morning to come to this talk, obviously, because you got up early to come to talk about licensing, you probably don't find licensing a boring topic. A lot of people do. It's similar in society to people talking about taxes, and since we just passed our tax filing deadline, this is the second time I've given this talk near tax day. I actually gave it on tax day in 2014 or something. It's a couple days after. I filed just in time, so I just recently did my taxes as well. I actually find tax policy fascinating because it's social policy embodied in a set of rules that decides whether or not you're taxed. And when you have these kinds of complex codified systems that tell you what you are and are not allowed to do and what you have to do as a citizen of the US, for example, that's creating some sort of policy, implementing some sort of policy decision about our society. So here's a great example. You're allowed to take deductions on your taxes, and I've thought a lot about why, over the years, why do we have tax deductions? Well, somebody in the legislature probably decided that this was a good thing for people to do. And so they made an incentive to encourage people to do it. So, for example, I work for a charity. If you donate to our charity, you get a deduction. Well, the reason that exists is because they decided it's really good if our citizens support charities. So we're going to make a policy that they pay a little less tax, that basically they don't pay tax on that money that they donate to charities, as a way to incentivize people to donate to charities. So they want to encourage, our government has decided to encourage certain behavior, and they don't charge taxes in certain situations. By the way, this is my personal opinion, not the opinion of my organization. The home mortgage deduction is a huge policy decision that we made, which has its ups and downs, right? There's a benefit of encouraged home ownership, but also it punishes renters, right? So I've rented most of my life. I've never owned a home, so I actually don't like that policy, right? Because I don't get a tax deduction for my rent, but people who own a home do. So there's this weird incentive structure that gets created, and that was a policy decision. I love to debate that sort of thing. Like, you don't meet many people who want to debate the home mortgage deduction, but I do if you want to debate it after the talk. And then there's tax penalties, right? There's things that you do. For example, if you take your money out of your IRA too early, you have a penalty that you have to pay on your taxes. And why is that? Well, because they want people to save for retirement, so they don't want people to go grading their IRAs every year to get money, so they charge a penalty if you go and do that. And they want to discourage that behavior, so they create a policy. And as I've just been doing, you can argue about what the right policies are. It's not like, so many people look at things like licenses or tax policies and say, well, that's just how it is. Well, it's not just how it is. It's our government, we're a republic, we decided that we wanted these rules and we should debate them. And the same is true about licensing. This is why I think licensing debates are good and reasonable, because those are policies, and these are the policies of our community. We should debate them if we want to. We should talk about what they do and why they do it and how they should do it. And I I think that if you think about the way we have these kinds of policies in society, it's really similar in free software, and we should be willing to talk and think about them. So, I guess we just said that. So, you'll see the same effect happening that I've been talking about in free software licenses. You'll see different licenses permitting certain behaviors because the license author wanted to encourage those behaviors, just like the tax deduction example. And you'll also see some free software licenses put extra requirements on certain things if you engage in those activities. And those extra requirements are very much like the tax penalties. They're designed to discourage behaviors that the license drafter felt were bad policy for their projects, for their free software projects. So now actually 25 minutes in, we get to an actual license. So this is probably the simplest free software license. It's Michael Dexter's favorite. Not anymore? It used to be.
It is, no, it totally is.
Yeah, it's Michael Dexter's favorite license. And so there's actually one simpler than this, but it has curse words in it. So I don't know if putting the simplest free software license that exists, it's to do with the F you want license. And I think I violated the code of conduct if I put that on the slide, so I use this one instead. So it's very simple. It's giving you all these permissions. You have the permission to use, copy, modify, and distribute. Those are all the three things I talked about that copyright law governs that we want to have software freedom for. With or without a fee. So there's the commercial versus non-commercial thing. You can do the activity commercially, you can do it non-commercially if you like, and those rights are granted, and then you have to keep the copyright notice in place. Now, it's interesting to note, even in a simple, the simplest free software license, or the second simplest free software license, there is a requirement. There's a policy requirement, right? There's this attribution requirement. And that's interesting to note because a lot of people who prefer these licenses, not Michael, but others, always argue that, oh, that's, the GPL has all these requirements. Well, even their licenses have requirements, right? Everybody basically believes you shouldn't just be able to do whatever you want. I guess the people who use the do what the F you want license believe that, but even people who pick this license say, well, I want you to be able to do all those things, but I really want credit for my work. So I want you to leave the copyright notice in place so it shows that I did the original work on this. And that's a reasonable thing to ask for, and even the simplest licenses do. Now, what license people pick and what they put in their terms really depends on what their goals are in writing the license and their goals, and once they pick a license for their software, their goals in writing the software. So every license you're going to see is always granting those freedoms for the first recipient. So in this case, when you receive this software, you have all those rights when you get it under the ISC license. Now, pretty much everything I'm going to talk about is about what happens after the first recipient, right? So the first recipient gets this free software. Then what about the person you give it to next? What are the rules that govern the next step? That's pretty much the real difference between what are called copyleft and non-copyleft licenses, which I'm going to get into now. So the goal of a copyleft license is to encourage everyone to share and share alike. To encourage, as the second and third and fourth recipient downstream receive the software, the goal of copyleft is to encourage that everyone gets exactly the same rights and freedoms, that they don't change. See, under the ISC license, you can turn that into proprietary software. You can take those permissions away because there's nothing stopping you in the license, so you can add your own proprietary stuff to it. You can just not give the source code to people. You can give them binaries only. You can add additional terms on top that have an NDA. All those things are allowed with those licenses. Under copyleft licenses, that's not allowed. And the way that's accomplished is by using the copyright system that's there already governing all software, as I talked about, by adding requirements, by adding those kinds of penalties or requirements of things you have to do when you redistribute. The most important requirement in those is the requirement to give the complete corresponding source code to everyone who receives the software from you. And the reason this is important is because the easiest way to take people's right to copy and modify, or to simply modify away, is to give them a binary-only copy. Modifying a binary is extremely difficult to do. It's not impossible, but it's very, very difficult. So your software freedom is curtailed if you get only a binary. So copyleft licenses use the copyright system and say, yes, you may distribute binaries. You're allowed to do that. That's part of your software freedom. However, when you do that, you have to make sure you're giving the complete corresponding source code to that binary to whoever you distribute to. And the other thing copyleft licenses do is when you modify the software, you must also give your modifications when you redistribute. So if you distribute your modified version and make a binary, you have to give the complete corresponding source code to the modified version, not to the old version that you got from upstream. And usually, these copyleft requirements are triggered at the distribution moment. They have to be hung on some copyright requirement, right? Because since copyright is the governing legal system, you can't add a requirement that doesn't somehow hook back in to copyright. So most copyleft licenses that you'll see will trigger these requirements on the distribution. And since copyright law governs distribution, you can set whatever rules you want under copyright to tell people what they have to do if they want to distribute your copyrighted software. And in the case of copyleft, it puts these kinds of requirements. Now, the one thing I want to note, and I don't want to get into it except in the Q&A if you want to ask it at the end, but the Affera GPL actually triggers the copyleft requirement on modification for a certain policy goal that we can talk about at the end, but it's a little bit beyond the scope of this talk. So there are also other types of policies other than copyleft policies that are implemented in licenses. It's very common to require in a free software license the carrying of warranty disclaimers. This is important because in a lot of jurisdictions, particularly in some states in the United States, if you don't disclaim warranties, you automatically give warranties on software when you distribute it. So some of the software licenses, basically to protect everybody, have the requirement that you continue to carry along warranty disclaimer so the copyright holder isn't later sued for a breach of a warranty that they didn't mean to provide. There are a lot of things that's a little bit beyond the scope of this talk about patent policy in a lot of licenses. Software patents are a huge threat, and they're a separate legal system, right? So copyright and patent can govern software at the same time. You can have copyrighted software that you wrote yourself that infringes a patent you've never heard of. It's a bizarre system. Software patents should absolutely be abolished, but we have them right now. So what a lot of free software licenses have done is they've implemented various things to mitigate the patent problems in the world in the copyright license. So again, they use the copyright hook, they use those hooks on modifying, distributing, and say, if you distribute then, there's certain things you have to do with your patent licensing too. For example, in the GPL v3, it says that if you distribute software, you have to grant a patent license on any patents that the copyright holder has on that software they distribute. So that makes sure that when you get a copy of GPL v3 software, you have an explicit patent license for the patents that the copyright holder had when they shipped you the software. So that's one example of patent policy. There's lots of different licenses that have various complex patent policy stuff, which I'm happy to take questions on at the end if you want to dig into that. And the final thing you see a lot of, which we saw in the ISC license example, is some sort of attribution requirement, making sure that people are told about who wrote the software and give them credit. So you'll find that a very common policy requirement. So this is a kind of a graph that I drew, and I'm not a very good artist, so it's not a very good graph, but it shows basically the spectrum of software licensing. And I don't think it's a two-dimensional world, free software licensing. It's much more three-dimensional, so this is simplified. For example, the patent policy is not really looked at in here, so that's sort of like another z-axis that would be here if you wanted to make it a more complex graph. But this is a general approximation of the trade-off between copyleft and non-copyleft. So as you go towards the left here, you're getting to more highly permissive licenses that allow you to create proprietary software out of the free software. And the usual trade-off between copyleft and non-copyleft is adoption versus software freedom. So if you choose licenses more towards this side of the spectrum, you're giving permission for companies like Apple to take all of your work, put it into a proprietary product, and give nothing back to the community. And Apple has in fact done that. Apple just loves MIT license, ISC license, 2-clause BSD software because they hate software freedom. They want to lock down every device they can, make it so no one can change it, no one can modify it, no one can improve it, no one can learn about how the devices work. So they take this free software, put it into their product, and lock it up. But it's very popular, right? I mean, Apple won't touch anything on this side. They're unbelievably allergic to the GPL. And the reason is they don't want to give anyone software freedom. But those on this side of the spectrum will argue, well, I want my software to be popular. Popularity is the most important thing to me in the world. I want to be famous and popular. And if you make non-copylefted software, you have more chance of getting famous and popular because more companies will adopt your software. If what you care about as a policy decision is getting more freedom to more people, you want software freedom to expand and improve, and you want more free software to exist, you want to pick a license towards this side of the spectrum. Because you're sure that downstream from you, no Apple can come along and take the software and proprietarize it. So it's a policy trade-off. I obviously, from the way I'm speaking, you probably guess I lean towards that side because I care a lot about software freedom, but it's a reasonable policy decision that people want to make on the left-hand side and say, well, I prefer to get my software adopted more than guaranteeing software freedom. Those of you that are licensed experts might wonder why I put Apache right there. That's trying to hint at the Z-axis thing because the Apache license is the best non-copyleft license with regards to patent policy. So it's generally better, I think, if you're going to pick a non-copyleft license to pick the Apache software license because it has patent terms in it that helps mitigate the software patent problem. Everything to the left of that do not have any explicit patent licensing or details in it. Now, there's a very good article written years ago by a colleague of mine named Dan Ravisher, who's a patent attorney, talking about how actually even these licenses do grant implicit patent licenses. Now that's never been litigated, so it's touchy. And actually GPLv2 doesn't have an explicit patent license, so that applies to GPLv2 as well. It's good to know that there's a good legal argument that you do get an implicit patent license, but it's better if you get to pick the license for your project to pick one that has an explicit patent licensing term in it, like the Apache software license or the GPLv3. I also have things in here with these exceptions. So one of the things you can do with a copyleft license is you can pull it towards the more permissive side by adding an exception to it. So you say, well, I want my software to be copyleft, but I want to allow certain types of proprietary uses that otherwise the GPL would prohibit. So you can write these exceptions as ways to move yourself a little bit more to the permissive side from a strong copylefted side. The GCC exception, for example, is designed to allow, so when you use a compiler to compile a program, certain parts of the compiler itself get copied into the output of the compiler. So just basically the initialization code to get the program running, those kinds of things usually come with the compiler and get copied in during compilation, which would of course cause everything to be GPL'd that's compiled with GCC. It wasn't the intent to do that, so a lot of the GCC code has this exception that allows for software compiled with GCC to be allowed in proprietary software under certain terms and conditions. And I actually helped write the current version of the GCC exception, so I can take questions on that, but it's highly complicated license policy, so if you don't want to get too deep into this stuff, don't ask about that. So the last thing I want to talk about, and then we'll just open for discussions to have so few people, we can leave a lot of time for that, is issues that are about licensing policy, but are not actually embodied in licenses. And this has happened in the last 5 to 10 years. We've started to discover that there are ways to, like any system, you can game the system a little bit. And people have used various techniques to use copyleft, but then have some sort of side situation where they collect all the copyrights for everybody so they can make proprietary versions, those kinds of things. So I generally am a believer in this concept of inbound equals outbound. And what that means is when you get contributions from the community, every individual holds their own copyrights on their own contributions, and they give you their changes under the same license you gave them. So that ensures a certain amount of equality. So if I write a GPL program, and you all send me patches, you all have your own copyrights, and now we're both copyright holders in the work together. And we both have GPL obligations to each other. So I have to obey the GPL with regard to you, and you have to obey the GPL with regard to me. A lot of companies now use these other types of arrangements, like a contributor license agreement or a copyright assignment agreement and other types of things to create basically inequality in the community. So they say, okay, I'm going to put this GPL program out, and if you want to give me any changes, you have to agree to assign all those copyrights to me. Because what I'm going to do is go into business selling proprietary versions of the software, because I'm allowed to do that as copyright holder, because I have all the rights, so I can release one version under GPL and then release another version under a proprietary license, maybe with even some other proprietary add-ons that I've written separately. So that, I believe, creates inequity in the community. And initially, a lot of people in the copyleft world thought, oh, this is a reasonable business model, it's a way to raise money. But as we saw with MySQL AD, that model quickly becomes corrupt. They tended to shake people down about MySQL licensing. So they'd find somebody using MySQL under the GPL and walk in and say, it's a pretty nice company you got here. It'd be a shame if you were violating the GPL on MySQL, so maybe you just better buy a proprietary license from us. And so I said, well, no, I'm not violating GPL. Well, are you really sure? Maybe it's better. You just slip us a couple of bucks and we'll just leave you alone. How's that sound? Right? And that's the business model that came out of this kind of for-profit corporate control of copyright of copylefted software. So I kind of believe that if you believe in if you've chosen a license policy that's good for your project, it should be good enough for everybody in your community. Everybody should be bound by the same license, even yourself. And I don't like it when somebody's not bound by their own license because they've collected licensing agreements from every contributor. Now, on this, I should note that charities do take copyright assignment, and I think it's a different situation. So, for example, the Free Software Foundation asks people to assign copyright on their programs for reasons being that they want, as a policy matter, to be able to enforce the GPL for their GNU works if they're violated. And that's actually a much different situation because, first of all, the FSF in their copyright assignment agreement promises to abide by basically meta language of the GPL themselves, and they're also the stewards of the GPL. And they're bound by the IRS, a whole other legal system, to only do things that are in the public good because they're a charity. So that's very different than giving copyright to a for-profit company. But generally speaking, I used to be a big proponent of assigning copyright to the FSF. I have assigned some of my own copyright to the FSF, but I generally think projects are better when they're multi-copyright held. There was a worry that years ago that the GPL might not be enforceable if there were lots of copyright holders. And I'm pretty much the person that's proven that not to be true because I did a lot of the enforcement on the BusyBox project, which was a multi-copyright held work. So now that we have that legal certainty that GPL is enforceable for a multi-copyright held work, I don't think that there's an absolute need that we need to assign our copyrights to a charity, but I think charities do act in the public good, so there's not really danger there either. So how many people are Mac users in the room? Any? Yeah. How many use some form of GNU Linux? Right. Okay. So the interesting thing is that you're both using free software, right? This is back to my point about Apple, right? Yeah. Unix. Yeah. Right. But poor Michael does not have software freedom on his Mac, right? Because he doesn't get the source code.
Correct.
And those of you that are using GNU Linux systems, you have software freedom. And that's a policy outcome of two decisions about free software licensing. And I know Michael's sad that I'm very anti-BSD in this talk, but I'm not necessarily judging it, right? I mean, I sound like I'm judging, but I'm really not. Like, it was a decision they made because they wanted the software to be adopted. Apple would not have adopted it if the BSDs were GPL'd. But it has an interesting outcome of what happens in the final policy conclusions once that starts to act in the world over a period of years. And this is why I'm a fan of Copyleft, because I want to be sure that when I get a software from a company that I have software freedom. And strong copyleft is pretty much the only way to assure that, because companies will take advantage of whatever edge they can find. And the GPL is a tool to help encourage the policies that I think we want in the free software world. So with that, I'll just point to this resource. So I help edit this thing at copyleft.org, which is a comprehensive guide of how Copyleft works. It's a copylefted project itself, so we welcome contributions and improvements. And even if you don't know that much about this, you can help us, because there's plenty of typos, there's plenty of just bad word, like, you know, it's a lot of stuff that's been written over a period of years, and sometimes someone's written in second person, someone's written in third person. So there's actually lots of interesting editing work to be done if you just speak English well, which I'm sure all of you do. So you could get involved and contribute to that to help educate people about Copyleft if you're interested. And I do work for a charity and you can become a supporter, which is a big help to us to continue doing our work. And that leaves us a good 20 minutes at least for questions and comments and discussion. So, yeah, go ahead.
So I work on a project that says it is dual licensed under MIT and Apache 2. What does that end up meaning on your scale of relative freedomness of it?
So this dual licensing thing is relatively common. So what you can do, so what this project's doing is they're basically taking this disjunction of two licenses. They're saying they actually have a meta license, that's not really a meta license, but an overarching license, which says you have permission to copy, modify, and distribute this work under either your choice of MIT license or Apache software license. Now, your question's an interesting one because the implications, the main difference between the MIT license and the Apache license are the patent provisions in the Apache license. So the question becomes, what happens if you redistribute the work under both licenses with both permissions? Do you, as a company in this case, that would likely hold a patent, do they grant the patent terms under the Apache license when they do your choice of? I think we don't know the answer to that question. So, because it's never been, one of these dual licenses has never been litigated, and there's never been a case that I know of where someone has tried to sue for patent infringement over a dual license project, and the defense would be, well, wait a second, you gave it to me under the Apache license, which gave me a patent license. And their argument would be, no, we gave it to you under this license that allowed you to later put it under the Apache license, but we didn't put our work under the Apache license. We put it under this overarching one that gave you permission to do that later. So that would be the argument in that case. And I don't think we know the answer to how that argument will come out. I would argue that they did give it under the Apache license, but I'm sure they would argue the opposite, especially if they were a patent troll. So yeah, I'm sorry I don't have an answer for it. I think the world doesn't know.
So I went to Deb's patent talk here yesterday, and she was saying that you cannot patent something if there is prior art, if you can prove that it already was a thing before you tried to patent it. So doesn't just publishing your source code prevent some random person from trying to patent your thing?
So keep in mind, I'm good friends with Deb, but keep in mind she works for a pro software patent organization. So she probably overestimated the likelihood that prior art is all that helpful. There are two reasons prior art's not that helpful in the end. One is that the software, the US Patent Office does not examine at the patent granting time any prior art other than what either the patent holder submits them, the patent requester submits themselves, and obviously they're not going to submit prior art that's going to be bad for them to get and cause them not to get the patent, or other patents. So previously granted patents. So that's the only two prior art things they look at: their own patents and what they were told by the person who wants the patent. So it's highly unlikely that prior art helps you at all at patent granting time. Then it just becomes a defense. So if you're sued for patent infringement, then you can spend millions of dollars in litigation saying that that source code was prior art. And generally speaking, the way patents are drafted, it's often very hard to know what they actually cover. Most patent lawsuits are about whether or not this patent actually, they say, reads on this technology, this software. And so you have this huge debate of, well, does it really read on the software, and was this other software over here prior art for it? That's millions of dollars of litigation you end up spending, which is why the entire software patent system ought to be abolished. Unfortunately, because of the way our legislature works in the United States, that's a very hard thing to do, but it's an incredibly dangerous thing. So I basically have become completely uninterested in trying to do prior art because it just doesn't help enough, and it's a lot of resources. There was a time when people were encouraging, actually OIN, Deb's employer, still encourages developers to publish prior art documents with them, because there's these type of documents you can do that the patent office is more likely to look at than source code. I think it's a waste of time because it doesn't actually mitigate the problems that are there. So, yeah, Michael.
Is CC0 synonymous with public domain? And so the international implications?
It's a good question. So CC0 is published by the Creative Commons, and it was designed to try to be public domain waived. So I didn't talk much about public domain, but there is, in part because public domain has basically disappeared due to the Disney Corporation. And by that, what I mean is copyright was supposed to be for a limited time. The constitutional imperative to copyright is Congress shall have the power to grant for limited time certain monopolies, paraphrasing slightly from the Constitution. So that is the clause in the US Constitution that allows copyright to exist. But as has often been said, Disney has bought perpetual copyright on the installment plan by simply lobbying Congress every time Steamboat Willie's about to fall out of copyright to ensure that the original Mickey Mouse cartoon stays under copyright forever. So in all of our lifetimes, there has never been things falling. Actually, I'm old enough. In my lifetime, some things fell into the public domain because I was born in '73. But everybody born after '76, you've never seen anything fall into the public domain in your lifetime. It's pretty disturbing.
Birthday.
What's that?
Happy birthday.
So, so the reason that was is because it was not created. It was created before '76, right? That's the only reason. And what happened was that in that Happy Birthday case was they finally showed that the original song, or I'm sorry, the secondary song that supposedly was the more recent copyright grant was not a derivative work of the original, and so they got around it that way. But somebody finally fought that. But that had to do with two different works that were created at different times, which fell under different parts of the retroactive copyright controls. And now all the copyright controls, every time they're passed, are retroactive. So
SQLite is an example where they.
Right, well, I'll get to that in a second. So let me just finish on this point about, so what CC0 tried to do was it tried to say, people said, I want to just put this in the public domain. I don't want my copyright to copyright. Now, it actually turns out that the copyright statute, because of Disney, is so aggressive that it's basically impossible to put something in the public domain by affirmative action, by saying, I want it in the public domain. You can't actually do that. It's really disturbing. So what CC0 does is says, it's the intention of the copyright holder to put this in the public domain. If that's not possible for any reason, then the copyright holder grants you this very, very broad license to do whatever you want. So it's basically a public domain waiver for the places in the world where you can put something in the public domain, and then a fallback license for the places in the world where you can't. Which is it's kind of a smart solution. It makes it very long, right? Because a lot of people just, I want the shortest possible license I can do. If you want the shortest possible license, you probably just want the ISC license. Because CC0 actually is trying to get something done to put it in the public domain, which is actually really hard. And so just saying it's in the public domain. Now, Michael brought up, I'll get to your question in a second. Michael brought up the SQLite example. Well, what he's been able to do is he's gotten signed documents from everybody granting very, very broad licenses. And so he says SQLite's in the public domain. It really probably isn't. It probably is under an extremely permissive license, which he's collected from everybody. Because can't really put anything in the public domain. I talked to I forget his name, that guy who worked on SQLite, what's his name? I forget his name. I've talked to him about this, and I cannot convince him that he can't actually put something in the public domain. He will not believe it. But he's done very good work to collect documents that prove that he has a broad license to everything. So I think you can consider it under like ISC or CC0 effectively. Yeah. But it's not really in the public because you can't disclaim your copyright. The Congress really wants you to have control of your work. You and Disney, Michael, they want us to just control of your work. Don't give up control of your work.
And I see it because
I'm going to get to this question.
The public had a notion of public domain, and we're trying to reach the public, and we're kind of left hanging.
Yeah, I think it's better to tell the public there is no public domain so that people get outraged about this fact. Anyway, go ahead.
I was just going to make a comment that this extremely similar discussion was in this exact same room was talked about with the build of a book scanner for books. Mm-hmm. Almost the exact same discussion, and about the same topic about the frustration about lack of public for books too.
Yeah, I mean, any book since '76 is still under copyright, and then that's a good example. I'm sure they talked about during that session that books are out of print, and you have to violate the law to copy them, yet nobody wants to publish them. And so there's lots of cases like that. It's very unfortunate.
You came across the constitutional reference earlier. Can you give me a specific on that?
I have a copy of the Constitution on my, if you want to.
I mean, what you were referring.
Oh, so the clause in the Constitution that allows for a copyright system to exist says Congress shall have the power for limited times to allow for monopolies when it promotes progress in science and useful arts.
Okay, thank you.
It's not an exact quote, but search for limited time and progress in the copy of Constitution.
I've got that, yeah.
Yeah. We got plenty more time, like 10 more minutes.
So kind of a novice question about preserving copyright notice. So let's say in like the ISC, somebody gets the work, they want to relicense it. Do they have the ability to ignore the copyright notice if they relicense it under something else?
No, actually. So they do, and this is the ISC. It's funny because people say, "Well, you do all this GPL enforcement." I've actually done ISC license and MIT license enforcement too, because that's the most common thing that's violated with those, right? So you have, so particularly if you make a proprietary version, it becomes important. So the reason I say that is the copyright notices are usually in the source code. So if you're shipping the source code, you've preserved the copyright notice and you've made sure it's in there. But if you're not shipping source code, you have to copy all those copyright notices into like a documentation, and in some cases, like in the 2-clause BSD license, it actually requires you to put that copyright notice in the documentation. It literally says the copyright notice must appear in all in the documentation of the redistribution of the project. So if you put it into proprietary software, you've got to make sure you put those copyright notices in the right places. Now, it's an easy thing to cure. So if you go to the Palomita talk later, he's going to tell you that the world is ending because you don't buy his products to scan your software and you're missing all these copyright notices. The fortunate thing about the copyright notice clause, it's really easy to solve, right? So if you forget to put a copyright notice, and you just put it up on your website, like when they contact you, and it's an easy cure. It's much easier to cure than the kind of GPL violations we see. But yes, if you make a binary work, you're going to have to move all those copyright notices, which is a great reason just to ship the source code, because the source code has all the copyright notices in it, so it makes it easy. So it's much easier to give software freedom than it is to make non-freedom. I'm going to I'll get back to you, Michael.
So with the permissive licenses, you usually hear about people relicensing them proprietary. Are there many roadblocks for most of those licenses for taking them on copyleft?
So that's why I mentioned, actually I forgot to talk about this. I mentioned the issue of GPL compatible licenses. Way back there, yeah. So I actually forgot to mention that. I promised to mention it later and I didn't. GPL, good, please. There are non-copyleft licenses that are GPL incompatible, which means you can't combine that software with GPL works. So the BSD advertising clause, the 4-clause BSD, the old one, that's an example of something that's GPL incompatible. Most non-copyleft licenses, highly permissive licenses, are GPL compatible, which means you can take that work, combine it with the GPL work, and distribute the result. So there's not, for most of those licenses, if they're GPL compatible licenses, there's not really many roadblocks at all. You can combine them all together and it's permitted.
But I mean, can you also release the whole thing as GPL and require people who, modify your version that you're distributing, like for the whole project, basically? Can you rebrand it as GPL without permission from each of the copyright holders?
Yes, you can. If it's GPL compatible, that's actually what GPL compatible means. So the way copyleft works, strong copyleft at least, is that the GPL applies to the entire work. And if you create that work by adding lots of components from different sources, you will have to put them out under a GPL license. Now, the GPL compatible licenses allow you to do that, i.e. you can put it on a license. And think of it on the other side, we're putting a proprietary license, right? So the ISC license allows you to put a proprietary license on top if you want to, i.e. make it an NDA-based license. Similarly, you can put the GPL on top of that, making it a GPL work. Now, generally speaking, as a social act, it doesn't make much sense to apply the GPL to something modified. So if you just technically, you can download a copy of FreeBSD, take all the 2-clause BSD parts and just put the GPL on it and redistribute it. The point of that would be pretty meaningless because somebody could just go get it again under the 2-clause BSD license from the FreeBSD project, and also would be seen as a pretty antisocial thing to do. But if you made improvements to FreeBSD, sure, I mean, certainly you should GPL them. Now, FreeBSD won't take them upstream, so you have to consider the fact that you're now maintaining a fork. But those are all kind of social issues that would come up. There's no licensing restriction on doing that. Yeah.
Sorry, going back to the constitutional issue I've got in front of me. It was Article 1, and where is that about Congress?
So you search for limited time.
Okay, thank you.
Limited time is to say Congress shall have the power for limited time to create a system. I mean, why don't you read the quote out of it, but you find it, because I don't have it exactly right, but
I
have
can find it.
Yeah, read it when you find it. Read it out. Go on, Michael.
Just an observation. In your presentation, BSD is synonymous with Apple, whereas one can have complete software freedom using BSD licensed tools, and there's a very strong community engaged in exactly that. And it's just a wee disingenuous when you give a choice of using Linux, using Mac, using a complete family of operating systems and application software, where there's, dare I say, a sharing community that thinks you're an idiot not to share the source.
Right.
Consumers with money should demand source, because they've got the money.
So Michael's trolling me a little bit. But yeah, I mean, you and I have talked about, Michael, the fact that there is. I mean, I've now infamously said that Faraday Rott of the OpenBSD project believes in the emotional copyleft, not the licensing copyleft, because if you take a BSD. Because Theo believes deeply in software freedom, but he doesn't put it in his license to require it. If you take OpenBSD and proprietarize it, he gets lots of people to email you and complain that you're not giving back to the OpenBSD community and send you nasty grams, right? Which has happened multiple times. Okay, you know that. Fine. And so that's a different kind of meta policy solution to software freedom, encouraging people to give back. And I think it's true. I think you're right, Michael, that most people in, say, the Apache Software Foundation stuff would say you should give your changes back to the community. They don't want an official policy to require it. That's the real difference, and that's what allows things like Apple to be able to pick it up. And my belief is that ultimately, there will always be bad actors who won't give back. You're not going to get everybody who, just by saying, please share. I used to be an anarchist, I did, but I don't think anarchy actually works, right? Because ultimately, bad actors will exploit the anarchy. And I think they have with BSD.
And bad actors that violate the GPL. So.
True, but we have a policy system, right? It's not anarchy. We have a policy system, the GPL itself, to do enforcement. That's why our organization does GPL enforcement, right? We don't just have to do like Fair does and send emails and beg, right? If in the end, we sue people if they don't comply with GPL. And we have a lawsuit right now against VMware, who took Linux and combined it with their kernel components to make a new kernel that they distribute as part of their ESXi product, right? So if they had just taken BSD, I would just be giving talks about how they're like Apple, right? But we actually have a legal mechanism, and that's the real policy debate, right? Whether you want a legal mechanism to ensure software freedom, or whether you want just to be able to say please. I don't think we should be in a position where we have to beg Apple, please give us some source code, please. Please, would you be nice? Oh no, you won't be nice. Okay.
All I ask is that you respect those who do share institutionally, both professionally and in commercial products and otherwise, because it does happen. Not everyone's a jerk.
Right, and I didn't. The only people I said were jerk or Apple.
Yes, and I agree with you completely.
So we're good.
I agree with you completely.
Let's change the topic.
Yes.
The thing that you were looking for was Article 1, Section 8, Clause 8, which reads, to promote the progress of science and useful arts by securing for limited times to authors and inventors the exclusive right to their respective writings and discoveries.
Mm. Yeah, and above that, I think it says Congress shall have the power above, because it's in the section where Congress has the power to create these things. I think that whole article is the things Congress can pass laws for. So.
What happened to the limited time part?
Oh, you talking about the
Disney.
thing, yeah.
Disney
Disney lobbied for perpetual copyright on the installment plan, is what happened.
Would it came from back from the Supreme Court that as long as it had an end date at the time they implemented, it's limited time, even if you never get that end date, because it keeps getting extended forever and ever and ever. It's limited at the time they made it.
Yeah. I mean, the idea that the argument was made in that case that authors actually wake up in the morning and say, gee, I think in the future Congress is probably going to make sure my great-great-great-grandchildren can still make money for this. So I'm actually going to write this work that I wasn't going to write, because if only my grandchildren would get money from it, it wasn't worth it. But my great-great-grandchildren can now get money from it, so I'll definitely make this work now. This is what the Supreme Court believes.
This is your strategy for why you're writing or not writing?
No, that's what the Supreme Court said is happening. They said that the authors are expecting copyright to be extended, and that incentivizes them to write works they wouldn't otherwise
If by
write.
authors they mean Disney.
Right, but they mean everybody, right?
What the heck planet are these legislators from?
So they're from our planet, and they're paid by these people.
Ah.
right? I mean, so yes, they're just corrupt. It's really just the answer, the simple answer. I think we have time for maybe 1 or 2 more questions. If anybody has any more.
And that's
Yeah,
an
go ahead.
extension of my prior question. If it's already copyleft, say GPL,
Mm-hmm.
is it possible to re-license that under AGPL without getting buy-in from all the contributors?
Yes, if it's GPL v2 or later, or GPL v3 or later, there's a compatibility clause in Section 13 of GPL v3 and the equivalent section in AGPL Section 13 that allows you to make a Pharaoh GPL modifications to a GPL v3 work. Now, the compatibility clause is weirdly drafted. I once had a 6-hour meeting with Stallman discussing the words "as such" in that section. Because I think his idea of what was supposed to happen is not actually what the word's saying. I think he agrees with me. But the general intention of that clause is that you're supposed to maintain the GPL v3 parts as best as possible under GPL v3 while you add on things that are under a Pharaoh GPL. And I think Stallman thought that it was somehow you weren't able to make AGPL modifications to GPL v3 works, but the clause clearly allows that. So you can definitely, he and I talked about it for a very long time. I'm pretty sure the intention and the words actually say that you can do that.
But so in that case, the AGPL wouldn't cover the whole program, like the GPL wouldn't be so different?
So I mean, I think it's the same outcome you get anyway with any time you combine works, right? So if identifiable sections, so take the other example of ISC license stuff and then adding GPL stuff on top, right? So if you have like a dozen source files and you only change one of them, and it's clear you only changed one of them, the idea that you can't go back and use the other code under the ISC licensed, I mean, obviously you can, right? Because you can still show that it was under the ISC license, so you could take out the identifiable sections that were truly ISC licensed. Now, as you start to commingle things more and make GPL modifications to the ISC licensed work, it'll be hard to disentangle it. I mean, it's theoretically possible, right? Because your copyrights are separate from the other person's copyrights, and the other person did license their copyrights under the ISC license. But as a practical matter, to disentangle it eventually would become impossible. So it's really a question of practicality versus theory. So in theory, yes, the works stay licensed under the respective licenses. But in practice, you might not be able to find which line of code was licensed under the GPL v3 and which line was licensed under the Pharaoh GPL v3. Yeah, go ahead.
So, if we have a minute, could you speak to what's supposed to happen when a project was sitting out there on GitHub unlicensed for a while, and then the people who wrote the vast majority of it realize, oh, we meant to or need to put some license on it, whatever that may be, and they cannot get a hold of all the contributors. Like somebody's, let's say, changed their name, gone offline, no longer is using their account, yet they put a drive by.
Or is dead, right?
Yeah.
Just real quick, so this can be the last question.
Okay, sure.
Yeah.
So it's a huge problem, and it's why when you start a project, it's really important to think of what license you want to put it under, because you can end up in this situation. Ultimately, it's a question of risk. So will that person disagree with the licensing that you chose, and will they sue for copyright infringement? That can always happen. So what normally happens when you want to relicense a work in any situation is you try to contact every copyright holder, and you find for the copyright holders you can't contact the identifiable sections that they wrote and take them out and rewrite them. And with version control, this is usually relatively easy to do. One of the strategies you can do is just check out the version right before their patch, and then start from scratch to write it so the next patch applies, and then you're good. The libVLC was sadly relicensed from GPL to LGPL, but the process they used was very good. They went through and contacted lots of people and then rewrote some sections. Okay, I'm out of time, so you can come down.
And if you guys can keep talking